I've come to the floor to talk about the impact of the Laken Riley bill upon children here in the United States of America, and to suggest that we have a debate over several amendments designed to more appropriately treat our children that reside here in the United States so we do not end up doing significant injury to them, which I very much believe is going to be the result if we proceed without some changes. But let me start just by noting my thoughts are, as I think the thoughts of every senator, are with Laken Riley's family. Whenever there is a tragedy, no tragedy should happen, whether it's perpetuated by a citizen or is perpetuated by an immigrant. Americans should be safe in their communities, and it's absolutely clear we need comprehensive, common sense immigration reform. Here in the Senate, Democrats and Republicans worked together back in 2013 to just pass just such a bill. Enormous investment in border security 12 years ago, approved in this body by Democrats and Republicans together. That bill never got a hearing in the House of Representatives. So I hope we will, in fact, try to resurrect the spirit that inspired us 12 years ago in this coming year for comprehensive reform. This particular bill is very troubling in how it impacts children. I am troubled that a bill of such consequence and, quite frankly, legal complexity was brought to the floor without going through committee. Really, here in the Senate, the way to do responsible work on complicated, consequential bills is to have them go before committee so the committee can bring in all the experts necessary to resolve disputes and understandings about how the bill might work. From that common understanding, needed reforms can be implemented. But here on the floor of the Senate, where often only one or two of us are here at a time, there's no such consideration, and we can't bring experts to the floor here to resolve these issues. Now, my colleague from Alabama is here today, and when I propose that we consider certain amendments, I anticipate she's going to object, although I'll try to persuade her otherwise with the logic of my presentation. But I would say the core point stands, that this bill is consequential, it is complicated, and the potential impact on children is dramatic. So let's work to prevent something really awful from happening here in our country, because I know that's not the intent of my colleague. This bill, as written, requires ICE officers to detain individuals who have neither been charged nor convicted of a crime. Neither charged nor convicted. Children imprisoned without being charged or convicted of a crime. That's what this bill does. In the current system, children can be, in fact, detained, but it's at discretion on the front end and discretion on the back end to understand the whole of the circumstances. Is the individual a flight risk? Does the individual pose a risk to the community? Are we talking about an assault with a deadly weapon, or are we talking about grabbing and eating an apple while walking down the aisle of the grocery store? That discretion is obliterated in this bill. If a 5-year-old girl in either of our states, I'm from Oregon, and Britt from Alabama, gets hungry and grabs that apple, the Laken Riley Act says that young girl, if arrested, must be put into an ICE prison. Must be, without discretion. And there is no provision in the bill to get that girl out. There is no required review. This is an obliteration of everything we understand about due process. A child arrested but never charged because there was, in fact, in the end, no evidence, no conviction because since there's no evidence, there's no trial, is still sitting imprisoned without recourse in an ICE prison. This is not the America I know, and I don't believe this is the America my colleagues across the aisle want. So I come here to say, let's work together to fix this bill. That's what we're looking to do today. So, I have 3 amendments, and I will explain each of the amendments before I ask unanimous consent to set aside the pending amendment so that the amendment could in fact be debated and voted on. The first amendment excludes children from this bill. If the idea is that mandatory detention should apply to adults, then let's exclude children. Children would still be subject to potential detention that exists under the current law at the discretion. And in fact, under current law, they can be detained with discretion, even just for an arrest before they have been charged or convicted. But there's discretion involved. And I know of no case in which there has been permanent, mandatory imprisonment of a child who has only been arrested and never charged and never convicted in the entire history of the United States of America. And we're about to change that. And that is wrong. So I ask unanimous consent to set aside the pending amendment so that I can offer my amendment, number 73, that there be up to 15 minutes for debate on the amendment, and that upon the use or yielding back of time, the Senate vote on the amendment without further intervening action or debate.